holding up the meeting for a while. We finished the voting. May I invite Mr. Wong to continue his presentation?
The DOJ has put a lot of emphasis on legal education and training in Hong Kong because legal education and the profession serves society and also contributes profoundly to rule of law in Hong Kong. So people who are committed to legal education and training, they serve an important role. So therefore the DOJ supports the Standing Committee's work, including the comprehensive review on this occasion. Now on the last occasion, the training and education review work and the relevant consultant report was dated back in 2011, and since then there have been a lot of developments, and the legal profession also faces a lot of new challenges. In December 2013, the Standing Committee resolved to conduct a comprehensive review, and the view was to enhance professionalism and standards of legal education to meet with the challenges of the legal sector in Hong Kong. Now, to support this review, the DOJ back in March 2015 had provided funding of 1.5 million Hong Kong dollars as a gesture of support, and the terms of reference of the consultants have been provided, and these are in paragraph 4 of the document, and the report actually covers a wide range of subjects, including the present system of legal education and training in Hong Kong, the PCLL, and intern solicitors, intern barristers, and also overseas qualifications and so on. So the 38 recommendations by the consultants are included in the annex of our paper, and you can see that in the middle of last month the report covers a wide range of areas, and those who are interested in legal education and training in Hong Kong, they will definitely spend a lot of time on the conclusion and the recommendations of the report. The DOJ will also work through the Standing Committee and work with the other stakeholders and conduct discussions. We hope that all stakeholders, especially the two legal professional bodies and the 3 law schools and other stakeholders, can continue to maintain an open attitude and consider the recommendations of the report. And here the DOJ would like to reiterate that the legal profession is to serve the community. It should not be viewed as just as a business, and in fact the provision of legal opinion and legal representation is an important role in mediation, and every person, they play a role in safeguarding our rule of law. So therefore, any changes in legal education and training has to be based on the public's interests, and we're also willing to continue to listen from legislators and all the attendants in the panel. Thank you, Mr. Wong. So now I will invite the professional bodies, and I'll invite the Barrister Association, Mr. Edward Chan from the Hong Kong Bar.
Association has actually studied the 3 reports from the consultants with considerable details. There are altogether 3 reports. First is the interim report published in October last year. Secondly, there was the final report, which was published in April this year, and there is a further report which is published in May in answer specifically to the response of the Law Society to the interim report of the consultants. And these 3 reports actually, the Bar Association has read them in details, and in fact there was a committee in charge of that, and the conclusion of the Bar Association and the views of the Bar Association is already published in a paper dated the 21st of June which has been submitted to this panel. And really, those would be the main points of the Bar Association in relation to the views of the consultants. By and large, the Bar Association agreed with the consultants' final assessment, and in particular, the Bar Association also agreed with the conclusion that there is no necessity at the current stage to have a unified law school. And for the reason already given in the final report, which is further elaborated in the response to the Law Society's interim challenge. And therefore, for this reason, actually, I don't think that we need to go through the details of the argument of the consultant, because they are all embodied in the report. In relation to the views of the Law Society in particular, those were summarized in the consultant's last report published in last May. We also agree with the consultants, in particular, to their views on the desirability of having the LSE, the Law Society Entrance Examination. We agree with the views of the consultant in total on that score. And in relation to the view expressed by the Law Society, the Bar Association wants to enter the word of caution. Certainly, we agree that the Law Society should have a very important role to play on the admission of solicitors, but it is wrong to assume that the Law Society is alone the sole gatekeeper for the standard and the quality for admission to the, as solicitors. Obviously, we feel that since the PCLL is a common qualification, certainly stakeholders like the universities also have an important role to play on the standard of admission. And certainly the Bar Association, whose qualification is also derived from the PCLL, is certainly have a role to play. And in fact, of course, the standard of the solicitors would also affect the work of the barristers. And that's why indirectly, of course, the bar also have a role to play. And that is why we think that it is important that all the stakeholders should work together to devise a system for the qualification of the two legal professions. Plus the fact that, of course, that insofar as experience tells us that in the bad years where the trainee contracts are not in adequate supply, there is a rush of the people joining the bar. And the consequence is that, of course, that there is equally, likewise, a high dropout rate for those whose initial intention is not really to join the bar. And for all these reasons, we feel that we should respect the view of the consultants in their conclusions. But insofar as the overall conclusion of the consultants are concerned, there are two particular areas that the bar did not quite agree with the final conclusion. The first is in relation to the suggestion that civil and criminal procedures should remain as an undergraduate course and not moved to the PCLL. As a matter of record, of course, in the interim report, the consultants had once suggested tentatively that they should be moved to the PCLL stage. The Bar Association was in total support of the recommendation to move the two subjects to the PCLL stage, particularly because the PCLL, a lot of the applicants are from graduates of other jurisdictions. And therefore, it is a lot more convenient if they were all taught civil and criminal procedure in the PCLL stage. And certainly, because by definition, procedural law is quite different from jurisdiction to jurisdiction. And therefore, we feel that the university should really think thoroughly to decide whether they should really start teaching in the PCLL civil and criminal procedure. The other thing that we don't quite agree with some of the suggestions of the consultants is in relation to certain of the proposals on pupillage. We think that by and large the consultants are very much attracted by what they conceive to be the system in England for the operation of barristers. Barristers' chambers in England obviously are quite well established, and a number of them actually have members exceeding 100. Whereas in Hong Kong, in fact, a lot of barristers' chambers are pretty small, with, say, for instance, less than 10 members. And therefore, to really run chambers as a sort of corporation style, obviously, is not really the system that we had in Hong Kong. And therefore, say, for instance, to suggest that pupillage training should be put under a charge of a particular member of the chambers and so on, may not really be that really suitable for the Hong Kong setup. And furthermore, to suggest, say, for instance, that there should be a sort of central publication of vacancies in chambers, this sort of operation may not be really very suitable for Hong Kong. So on those scores, actually, we actually feel that the consultants had not taken into consideration sufficiently the local conditions. The last thing I'd like to mention is the recommendation of the consultants on the bar's LQE, Law Qualifying Examination. Now, that is not the same with the OLQE for the Law Society, because the bar's LQE was basically really a test for the transfer of practicing members, or members who had already had a lot of experience in other jurisdictions to practice in Hong Kong. And they are not really looked upon as sort of fresh barristers as soon as they pass the examination and get qualified to practice in Hong Kong. And therefore, the bar actually would feel that we should stick to the current system insofar as the LQE is concerned. Well, most of the arguments, in fact, are already set out in the written submission that we put before this panel. And I think for this reason, I really don't think that I need to trouble the panel members any further. I'll be prepared to answer questions arising out of our views as published.
Thank you, Mr. Edward Chan, Senior Counsel. Next, may I invite past President of the Law Society of Hong Kong, Mr. Stephen Hong. Good afternoon, Madam Chair. Before I speak, may I ask a question? Because on behalf of the Law Society, I'm going to give a very brief speech in English. I wonder if, Madam Chair, I should stick to Chinese or otherwise. You can use English.
Yeah, but I prefer to speak in Cantonese, but okay, I'll speak in English then, for the sake of the record.
In the full version, yeah.
Thank you very much, Chair Lady. Now, on behalf of the Law Society, I have this statement to make. Now, more than ever, the Society would benefit if more members of the public have good understanding of our laws. The Law Society has always maintained an open-door policy to allow an equal opportunity for law graduates who may become good lawyers to be given the opportunity to join the legal profession. At the moment, due to a less than transparent, some might even say biased PCLL admission policy of the three universities and the insufficient PCL places, some local and mostly overseas law graduates who would otherwise make good lawyers are deprived of the opportunity and legitimate expectation to join the legal profession. We are losing talents which may be detrimental to our legal profession. Law firms who employ trainee solicitors are telling the Law Society that students graduating from the three different PCL programs do not reach a unified level of high standard best suited to join the solicitor branch of the profession. Some graduates from 2 of the 3 PCLL programs are saying that they find it much harder to get the better jobs because there's a perception that only those who got admitted to the oldest law school are perceived to be the brightest and thus making them better lawyers. Without an independent unified examination, there's no fair opportunity for students to test and prove their abilities on equal footing. The Law Society has a duty to rectify these injustices. We are exercising our statutory powers under Rule 7 of the Trainee Solicitor Rule Cap 159 to set up the Common Entry Exam. I'll call it CEE from now on. We have publicly announced in January 2016 our intention to set a common entry exam as a result of after years of discussions with the stakeholders who have not shown openness to cooperate. The university have not given full cooperation to implement the CEE, so as to avoid a separate and additional set of examination to be taken by the PCL students. We are considering exercising our powers under Rule 7, bracket A, bracket 2 of the rules to establish the Law Society examination, LSE, as an additional pathway to PCLL. LSE will be an additional pathway into the solicitor branch of the legal profession. It is not something added on top of the PCLL. In fact, it is independent from the current PCL programs. To pass LSE, students will have to achieve the same standard as expected of the PCL graduates. So if the 3 PCL providers truly believe those admitted to PCL will make good lawyers, and those who fail to get admitted are not, then by analogy, these LSE students would be unable to pass the LSE no matter how much they tried. The purpose of our LSE is to allow those who were rejected by PCL an opportunity to prove themselves that they are worthy of a training contract with the aim to qualify as good lawyers. We are doing this for the betterment of the public. The Law Society invites all stakeholders to fully cooperate with us for the sake of the public and for the legal profession. Thank you, Madam Chair.
Okay. 多謝洪運叔.
Thank you, Mr. Stephen Hong. Next, may I turn to Mr. Brian Gilchrist?
Of the Law Society, please.
Thank you, Madam Chair Lady. Well, I wish I could use Cantonese. I think I better stick to English.
Yeah.
Can I just explain the thinking behind the introduction of the Law Society examination? It's to offer an additional opportunity to law students to take an examination that opens up to them the opportunity of qualifying as a solicitor and serving the community. It is not to add a further examination for students who've been given a place on the PCLL. Rather, there are a number of students who've obtained a good law degree who have not been offered a place in a PCLL course. There can be no justifiable reason why such a qualified student should be denied the opportunity of taking an exam that allows him or her the opportunity to progress to a training contract and to qualify as a solicitor and serve the community. There will be no lowering of standards. The test for competency to proceed to a training contract and qualification as a solicitor shall be the same, whether it is through an entrance exam such as the LSE or the CEE, or as currently the PCLL. The purpose of the LSE is to provide an equal opportunity to all intending solicitors to enter the profession so long as they reach the requisite standard. It is difficult to understand why there is such opposition to the Law Society's desire to allow for additional means for qualified law graduates to have the opportunity to take and pass an exam that would lead to them being able to enter the solicitor's profession. I thank you for your time.
Okay. Thank you, Mr. Gilchrist. 跟住落嚟呢就係
Next, Chairman of the Law Association of Hong Kong USU, Mr. Yam Long Hin. Please speak into the mic. Thank you, Madam Chair. The Law School of Hong Kong USU has the following points, where the Law Association of Hong Kong USU will welcome the final report's recommendations. I'd like to respond to the point raised by other deputations just now. When it comes to the PCLL course, we're of the view that setting aside the so-called unified entrance exam would allow us to look for a consensus and get an understanding from incumbent students in terms of the work opportunities and the legal profession, their views on the CEE. And in terms of the CEE, there are three major issues which students may be more concerned. First, the problem of monopoly brought about by common entrance examination. This is actually referred to in the report as well.
一啲嘅大學嘅院校啦，去成為管理呢一班嚟緊新進律師嘅一個嘅機構啦。咁亦都其實有機會係令到即係一班而家現職緊律師嘅人，同埋想去投身律師界嘅人咧，其實會有一個明顯嘅衝突喺度。
There will be a conflict of interest, and I think that conflict can be very hard to resolve. So if we introduce the ideas presented by the universities and the professional bodies, that can strike a balance and can prevent this conflict of interest. So when we promote the common entrance examination, this is one concern we have. And the second is about curriculum reform. Now, previously the Law Society had said that in 2002 that there would be a common entrance examination, but now there is already a tranche of students who are have a double major. They are already facing the CEE if it is promoted, and I don't want to see this occur. And I hope that when students take a law degree program, they need to consider what examination they will have to take to join the industry. And if we also consider that the CEE for students who wish to join the barristers, they need to acclimatize to the test format, and they are not optimistic. So when you promote the CEE or other similar examinations such as the LSE, we need transparency, and you also need to consult the students because this might be promoted in 2018-19. And the third point, our students consider, does it really authorize the Law Society to promote its own form of examination for entrance into the profession? So if we look at the public feedback, there isn't too much concern there. And if we were to undertake a large reform that would have a profound impact on students, I think that is not ideal. Well, your time is up. You might have an opportunity to respond when we reach Q&A.
Ho Wells, Dean of the Law School of City University, please.
Thank you, Chair. The City University welcomes the consultants' report as a basis for discussions about how to enhance the legal education in Hong Kong. And I should say the quality of legal education benefits a lot from the close cooperation we have from the professions. Obviously, at the moment, there's a lot of discussion about the Law Society's proposals for a common entrance exam or a Law Society examination. Over the time, I've heard three arguments about this relating to admission numbers, consistency between the providers, and most recently, desire to have more control on the entry course so as to meet the needs of the profession. As regards numbers, City University, we increased our numbers on the PCLL by 40 for the double cohort and have maintained those increased numbers. It's a political question as to whether there should be more places. At City U, we believe we could have a further modest increase in numbers if it was necessary. On consistency, the profession is involved in every facet of the PCLL programs. They review the syllabus, they attend lectures and tutorials, they review exam questions and answer scripts. We believe there are sufficient mechanisms at the moment to ensure consistency of standards, and haven't really seen any criticism voiced in our assessment panels or boards about the standards that are prevailing. In fact, I think there's a greater danger that if you introduce a second alternative exam, there'll be a more risk of inconsistency between the output from the different programmes being provided. On the question of the relevancy of the PCLL to the needs of the profession, I must say we're always happy to hear views of the profession about how the course can be developed over time, and we would be keen to engage in those discussions. And indeed, at all times we've been open to discussions with the Law Society about this and other stakeholders, and we would welcome continued dialogue to try to produce the best system for the students of Hong Kong.
Thank you, Professor Howells.
Next, we have Mr. Zhao Wei-sun, Head Department of Professional Legal Education, University of Hong Kong. Legal Education and Training, the Standing Committee, they had completed their report in April, and they looked at the undergraduate programs and the fine-tuning of PCLL. Well, Hong Kong U will continue to meet with stakeholders, and we will continue to look after the interests of the public and the students. Now, regarding the Law Society, where they had a support for this common entrance examination, but they now changed their position and put forward their own LSE. We are confused why they are doing that. They want the common entrance examination applicable to all three universities, and they also want to review the process. Subsequently, in November last year, they took the test papers and the scope of examination and invited the three law schools' opinion. We complied with their request, and as far as I know, the three law schools, the deans of the three schools, had met with representatives from the Law Society, and we have not heard from them since. The Law Society, we understand that they want to enforce standards in the society, but no matter what their legal status is, as the consultant report had repeatedly stated, but before there is full implementation detail, they want to insist a common entrance exam, CEE, and they say that they want to implement as soon as possible. This is going against their previous stance, and our students are perplexed. Because students don't know how they should choose courses and what examination they should take and what the exam format is going to be. Should they take the PCLL or the Law Society examination? So given such a short time frame, they won't have enough time to consider their options. The Law Society, pardon me for being blunt, this suggestion is not good for students. And I would like to urge the Law Society to relinquish their hold on authority and continue to look after the interests of society and students. And we need to negotiate, and I would like to take this opportunity to put forward two issues to the Law Society. For example, in the consultation on the CEE, and the Law Society seem to have questions regarding the quota and the standards for PCLL. They are concerned about the training contract. They seem to have different views. So I'd like to ask, does the Law Society have actual figures? How many students do you expect the universities to enroll in the PCL program? So aside from actual experience, are there any other conditions that you should need to consider? Thank you. Thank you, Mr. Chow. Next, from City U, we have Mr. Leung Hei-sun.
Entrance examination, regarding the Law Society examination, we do agree that even if the rejected students are given opportunity to enter the PCLL, this would only be for those that would try to be solicitors. But what about those for barristers? Those students may only have a chance to enter the PCLL through the school itself with their own results. And if they fail in their own results, they might not have considered the possibility that the Law Society of Hong Kong would have offered an examination to re-enter the PCLL, given that the Law Society of Hong Kong only regulates those of solicitors. So if we are to deal with this problem, we need to address the problem of fairness to those that only want to go for barristers. It might be possible that the Bar Association may also establish an exam that would allow students who are unable to directly enter into PCLL to do another examination to obtain a second chance. Regarding the Unified Law School or Unified PCLL Provision Program, it is submitted that there may be more confusion caused when the PCLL courses are merged, as the admission standards again will have to be recalculated. Different law schools have provided different standards of education, and with different courses provided, as stated before, it may cause students to be confused in choosing what courses they should study if they were to enter the PCLL. And finally, I would like to submit that universities are possibly admitting too many JD students. Statistics from the Chinese University of Hong Kong show that they have around 2 times as much JD students compared to LLB students. And with reference to the admissions of City University of Hong Kong, they're expecting to admit 115 JD students compared to 1 LLB student. By means of deduction, there would be 2 JD students entering into PCLL per LB student. And if this continues, there will be too much competition existing among LB students, and it would have a suffocating effect on those that try to enter the PCLL but are unable to do so because of too many competition faced by the sheer number of people studying. Thank you.
Okay, 多謝梁生。
Thank you, Mr. Leung. Next.
City of Hong Kong, please. Professor Hall.
Thank you, Madam Chairman, and it's nice to see you again in person after so many years.
Yeah.
I'd like to divide my comments into 3 parts. I'd like to first of all address the form and content of the PCLL. Then I'd like to turn my attention to the question of a law school examination, or the so-called common entrance exam. And then finally, I'd like to say a few things about numbers entering the PCLL. First of all, in relation to the form and content of the PCLL, Chinese University of Hong Kong has remained and remains now open to all discussions regarding the form and content of the PCLL, and in particular, we would like to emphasise our support for recommendation, at least the first half of the recommendation 6.4 in the recommendation of the panel of experts, that if there is to be any system of common assessment adopted in the PCLL for the PCLL providers must be involved in paper setting and examination arrangements for that. Chinese University has always been open to the views of the Law Society of Hong Kong and to all other stakeholders in the matter of legal education. I note that the Law Society is represented on the academic board of the PCLL program at the Chinese University of Hong Kong, and I'm informed that the Law Society representatives have never presented any serious questions about the quality or the way in which the PCLL program at the Chinese University of Hong Kong is presented. Turning our attention then to the question of the Law Society examination, I'd like to point out that we do not accept that there's a case for the introduction of the Law Society's proposal for a common entrance exam in their most recent proposals. In particular, they've not given any indication as to the alternative, to use their language, qualified vocational training programs, which they say will serve as a qualifying basis for sitting the Law Society exam, or even that it will be based in Hong Kong or provided by entities that are based in Hong Kong. The prepared start date in their proposal, which is 2019 to 2020, seems to us to be extravagantly optimistic, especially having regard to the far-reaching changes and the preparations that will need to be done in order to meet that deadline. We believe that there should be a moratorium. In this respect, we fully support recommendation 6.1. We believe that there needs to be a moratorium on the implementation of the Law Society's proposals, and in this respect, we fully support recommendation 6.1 of the report of the panel of experts. Thank you very much.
Okay, thank you, Professor Ho. Our next speaker would be Mr. Christopher Knight from Chinese University of Hong Kong Faculty of Law. Has he come?
I'm here, Madam Chairman, but actually the statement was made by my colleague.
Okay, you're together.
Yes.
Then I would invite Mr. Danny Gittins, Associate Professor, Hong Kong U School of Professional and Continuing Education, please.
Thank you very much. Hong Kong U Space would like to take this opportunity to highlight a different issue in the consultants' report from that mentioned by the other deputations today, and that's recommendation 4.5 on the proposal to create an advanced legal executive qualification that would allow some legal support staff direct entry to the PCLL. I'm sure all of us who've worked in the legal field are well aware of the vital role that legal support staff play, such as paralegals and legal executives. I mean, in the case of those working in law firms as legal executives, they already have to follow very detailed requirements laid down by the Law Society of Hong Kong. We at Hong Kong U Space run courses following those. Their experience is recognised by the Judiciary in 2 practice directions which allow legal executives certain rights of audience in the High Court and the District Court. But there is a basic issue of unfairness here, because at the moment, if they decide that they want to go on and actually join the legal profession themselves, they're essentially treated like school leavers. They have to go back to the beginning and start a law degree again. Many of them do quite successfully. But this is an area which, as was mentioned in the consultants' report, Hong Kong has fallen behind other common law jurisdictions, such as United Kingdom and the US, where they've long had procedures for recognising the experience and training that legal support staff can build up over many years of work. I mean, I should point out that in the United Kingdom, you've even had legal executives now, some of them have gone on to become judges. Nobody's suggesting anything quite as radical as that in Hong Kong, but the consultants do recommend in recommendation 4.5 that Hong Kong seek to catch up with other developments in other common law jurisdictions in this area, and that providers of legal executive training courses work with local law schools and the legal profession to develop a more advanced legal executive qualification that might allow direct entry to the PCLL. Certainly, we as Hong Kong U Space, as the largest provider of legal executive training courses in Hong Kong, would be very happy to work with the law schools and the legal profession to try and implement that recommendation. I must stress that there's no question of trying to provide some sort of backdoor route into the legal profession, anything like that. Of course, whatever final form this takes, all stakeholders would have to satisfy that standards are upheld. Also, as the largest provider of legal executive courses, we can provide some perspective. The numbers are not huge. I mean, we ourselves probably have about 40 students or so a year qualified as legal executives a year. But for those students, I mean, the Law Society representatives talked a lot about issues of equity and fairness at the post-PCL stage, but I would say this is an issue of equity and fairness at the pre-PCL stage, and hope we'd have members' support for this recommendation.
Okay, thank you, Mr. Gittins.
All right, our deputations have spoken. I'll now open the floor for members to ask questions. Please press the button now so that I can see what time we have. We have 4 members at the moment. Each member will be given 4 minutes for the first round. I'll try to allow everyone to have a go. Let's see if we have a second round. So let's start with Mr. Dennis Kwok, Deputy Chair.
Basic facts, right?
Please switch on the mic.
Yeah, I just want to get the basic facts right. How many potential students are you going to take on with the LSE? This is a question, obviously, for the Law Society. How many students are you looking at? Yeah, go ahead.
Please speak into the mic.
It's not how many students that we plan to take on. Our philosophy is that there could be 600 students taking the exam, but in order for them to pass exam, they have to reach the same standard as PCL student.
No, but you must have some idea.
May I just finish?
Wait,
because it could
okay.
end up 6 students out of the 600 can pass exam. So it's not how many numbers that we want.
But how many places do you have in mind? I mean, because you say that you want to provide places for those who couldn't get into PCLL, a chance to become a solicitor. I get that point. But what I'm also hearing from the universities is that they are too willing to increase the number of places for PCLL each year. Now, I'm trying to understand if the universities will increase their places for PCLL, say by 200 places per year. If that is enough to cater the same number of students that you are planning to take on through the LSE, then there's really no need.
No, there is.
Because if the universities are willing to accommodate that.
Yes.
Let Mr. Hong answer first.
Yes, thank you. The university has been telling us that they will increase places for X number of years. Okay. This is not the first year that they decided to tell us that they can increase the places. But my concern are those who have failed to get in the past. Now, we are talking about, let's say, this coming September, 200 more places. So the incoming applicants can benefit from the increase. But what happened to those who cannot get in and who's now working as a paralegal for the past 5 years? When are they going to have a chance to at least attempt an exam that they, according to what we predict, most likely they will fail because of standard? But my point is, I would like to give an opportunity to those who cannot get into PCL for whatever reason. Okay? Another chance. That's all I'm asking. So I cannot see why there's so much opposition.
So please allow the deputation to finish.
People who have failed in the past to get into PCL and you want to give them a second chance, that I get. But so what are the numbers you're looking at? Ballpark.
No, does it I don't quite understand
no, but you're
the
talking
question.
about potential pool. Let me finish. You're talking about a potential pool of people who you want to give them a second chance, right? That I get. But you must have some estimation as to how many people there are in that category.
So what do you suggest?
No, I'm asking you because you are coming to us to say you want to set up this new examination. Fine. But
no, I came here...
Let me finish. Yeah. You must have, as a professional body, done consultation. You have, as we all know, hire a consultant to do consultation in this respect. So what are the numbers that you're talking about? Because as the representative of the legal profession, I have to understand what is the impact this LSE will have on the profession as a whole. So all I'm asking is for some basic numbers and facts that you must have in your possession. Because if you're undertaking this huge project of setting up an LSE, you must have these basic facts in your possession.
Yes, Mr. Stephen Hong. Any response?
Hopefully I can get a, how should I say it, not permission, but an understanding from the stakeholders that what we propose is still a good idea. I mean, without that, why should I spend all the time and the effort to give you all the data, whether it will succeed, how many students can pass the exam? I don't think at this stage that is the issue. But
how do you not have those answers already?
Dennis, okay, wait.
Sorry, I already answered.
Let me pause you. I have to pause you. I do not want to stop people speaking in the middle, but I hope that all of you understand the rule here is you have to wait for the chairman or chair lady to call for your name. You are not supposed to overlap each other's discussion. But I just try to let you finish what you say. But our members, I hope our members also follow this rule, and just let our guests also know about the rule. So we wait. I will try to give a little bit more time, be generous to people who haven't finished, because I know this is a very debatable topic. Okay?
My apology.
It's okay. It's okay. Actually, I'm speaking to both of you. I hope that later on the discussion would be better.
Second one, Mr. Holden Chow. Thank you, Madam Chair. Well, I have this impression that we discussed this issue at the last panel meeting. My take is this. At the time when I was sitting in the meeting, I heard deputations raise questions on the CEE, especially from students, because they would not understand, well, they're concerned what the mode of examination would be. They're concerned about the future because, of course, the issue is very close to their heart and they are concerned. They may not understand the mode of examination or the requirements. So I think those students have repeatedly expressed their concerns. And before this concern is addressed, and if there is a suggestion that we should impose a moratorium, I sort of understand, because we really need to consult the stakeholders thoroughly and not to push it through too hastily. And I'd like to make another point. Professor Danny Gittings made some remarks, and I fully agree with him. In particular, recommendations 4.5 in this report regarding legal executives. They may not have the qualification, but they have ample experience from work. So it's a question of whether a mechanism should be set up for their experience or their qualifications to be recognized, and for them to have an opportunity to become a professional lawyer. I do think that we should give it a thought, because indeed there are quite some personnel who have not obtained the relevant qualification from a university, but through years of experience at the workplace, and these are practical experiences, they may very well have a very high standard. So I think that an opportunity should be given to them. The other point is this. President, I heard you. I think the intention is to give people a second chance. That is, if they fail the first time, they'll be given a second chance to join the legal profession. My view is this. I do think that we should put in place a similar arrangement. But well, if this is our common goal, if this is our shared objective, then I wonder if we can set aside our differences on, the details so that it can be implemented. So that's a comment. Do you have any questions? No? All right. Time saved. Next, Mr. Felix Chung. Madam Chair, I believe I am the only member without legal background here, because we have lawyers and we have law school graduates here. So let me speak from a perspective as a user or as a parent. I believe my comment will be more neutral. Well, let's say, may I speak as a parent? If my child studies law and graduates from law school, perhaps overseas, and if my child is required to undertake PCLL before my child is qualified as a lawyer, then my first question is about the PCLL courses from all the law schools, whether the number of places is sufficient, and also for overseas graduates, the proportion of them being enrolled in the PCLL course and the failure rate. What about those not being able to get in the PCLL course? They may need to take, for example, a 2-year part-time course, or they may need to wait a whole year before taking the exam again. So I think it's a sort of wasting our young people's time. Why must they wait? If the Law Society has this course design of an LSE, then at least we have a two-pronged approach for our young people. Even if they cannot get a place in the PCLL programs, they can still get an alternative. I don't think there is a big problem with that. But of course, when it comes to the details of the course or the criteria, I think the Law Society and the Bar Association should put their heads together and agree on a set of criteria. These are really the the two legal professional bodies you have in Hong Kong, I don't think there is a major problem. The problem is, first of all, lack of places. Why can't we give another choice to graduates and young people? All right, so that's a comment as well. Any question about the number of places and the number of applicants who have failed? Who would you like to ask, and who could respond to Mr. Cheung's question? Mr. Hong? You can speak in Cantonese. Well, I'm supposed to answer your question. Our design is that, first of all, the graduate must have at least an LLB or JD degree, and I don't remember this term in Chinese, but it's the benchmark of the Law Society. That is 2.2, second class, second division. That's the minimum requirement. That's what our LSE is about. We're giving opportunity for more people to take the exam, but it doesn't mean the exam has a lower standard. More importantly, we should give people the chance.
I hope I have answered the question. So you need to have an LLB degree. I agree with your view. The issue is if the universities don't offer enough PCL quota, they have the second-class honors from overseas. They can't. They don't. The admission to the PCL, they have to wait a year or two. Why aren't they given another chance or an alternative? Okay, time's up. Next we have Mr. Junius Ho. Thank you, Chairman. Just now I heard. I understand the issue. I declare that in 2011 I was chairman of the Law Society, and I have been a member for more than 22 years. And starting from 2001 or 2013, there were some reports. I understand those reports, but I'd like to be updated. So the Law Society is now calling for a common entrance examination, and it will be implemented in 2021. So Mr. Stephen Hong, the past president, said that it's not necessarily for PCL graduates, as long as they have LLB or JD and they take the Law Society common entrance examination, and as long as students pass, there is another route for them to join the legal profession. Is that correct, Mr. Hong? It's slightly different from what I want to express. Well, can I answer? The Common Entrance Examination and LSE are two separate issues. The CEE is for students enrolled in the PCL program. We want the three law schools to have a common entrance examination. The LSE is for people who weren't admitted to the PCLL. So the passing threshold will not be lower than the current PCLL. So that is what we want to achieve. Mr. Junius Ho? Well, my understanding is that we want another alternative for people who weren't enrolled in PCLL. They need another route to enter the profession, especially they need to be given an alternative to join the solicitor branch. Well, I don't see a big problem here, and therefore I want to ask Hong Kong U on this issue alone. From the Law Society perspective, they want to have a common entrance examination by 2021. So if with that date in mind, they are talking about a date in 2021, and they are already drafting a syllabus. So a legal profession, they want new members they expect certain standards. Where is your objection? Could you provide some more reasoning, Mr. Chow? Could Mr. Chow respond? Thank you, Mr. Ho. Let me provide some statistics. According to my forecast this year, new applicants to the 3 universities, the applicants for the PCLL, the total number will be about 1,200. And my understanding is the 3 law schools can provide roughly 750 seats in the PCLL program. Just now the Law Society representative mentioned an alternative route, a second chance, so to speak. Now, as far as I know, first of all, Hong Kong U, when we admit students, we have an interview for candidates who might be might have borderline academic results. So through the interview, they have a chance to enter the PCL program. Yeah, you can continue if you need to elaborate. And I understand that the City University, their PCL program also has an interview component for first-time applicants who have failed and who are making a second application. They are given a second chance. Now, just now the Law Society said that the Law Society examination they're proposing doesn't mean that the candidates will pass. So let me ask the question: in the Law Society, how many training contracts do they issue? If there are 1,200, and if all could take the PCL program, and let's say the pass rate is substantial, so can the whole industry supply sufficient training contracts to employ all these graduates? Okay, I'll give you some extra time for the second round. Next, we have Mr. Paul Jie. Thank you, Chairman. Well, the question is, where is the bottleneck? Is it at the PCLL, or is it at the training contract stage, or is it at the barrister level or the solicitor level? Just now, Mr. Stephen Hong expressed the view that they are impatient. They said they've been waiting X number of years for universities to increase enrollment. But universities have their own difficulties. But in principle, I also need to declare, as Mr. Junius Ho, I was a barrister. I'm a solicitor. I also took the PCL examination. I also have more than 100 employees dealing with the PCL. I also have mature students who wanted to change careers, and I also do not wish to offend anybody present, but at the early stages, a lot of young people complained to me and say that graduates from City U have a difficulty finding jobs. I like to employ graduates from City U because they are the underdogs and they are harder working. And I don't wish to offend Hong Kong U students. Hong Kong U students, they feel they come from a prestigious program. They're not as committed, as dedicated. So their commitment to the legal profession is perhaps not as they're probably not as committed as the underdogs. I'll use I'll give an example of SEND students, special needs, special education needs students. In the law programs, a lot of people start late. They didn't follow the traditional mainstream program. They might have worked a while and then go back to school. They might develop an interest in the law later in life, and they might have even better academic results. So I find these comments quite embarrassing. I think I would support the Law Society in this proposal because it's giving people more choice, and we need to give people who have not followed a mainstream career or a path, they might work harder later in life and found their interest later in life. They need these opportunities, and I also understand Professor Gittings or Mr. Junius Ho saying for practicing lawyers, they might have joined the profession through other means, but that's only half of the answer. They don't get a training contract straight after passing the LSE. So our previous Secretary of Justice joined the profession through an alternative path. They can qualify later in life as a solicitor. So hearing Mr. Hong, they're not here to get our blessing or approval. Maybe it's just they're just asking for our blessing. So also heard Mr. Kok Wing Hung, Mr. Dennis Kwok's dialogue. Well, we always have people speaking out of turn in LegCo now, and as a member of the legal profession, you should actually understand what is going on. You don't seem to be representing our industry, our profession. Well, Mr. Paul Che, you used up all your time. I'll queue in the second round again. We have Mr. Alvin YEUNG next. I have nothing to declare. I'm just a junior barrister. I just took the Hong Kong UPCL program. So I'd like to ask Mr. Hong, past president, solicitors, when they practice, they need to swear an oath. They have to be responsible to the court. So I want to ask the Law Society, they've come up with a very innovative LSE recommendation. Have you consulted the Court of Final Appeal Chief Justice, Mr. Hong? I don't think so. I'd like to ask Mr. Hong, I believe, Mr. Hong, you are so innovative. You want to come up with the new posts and opportunities for the legal profession. I want to understand the Law Society, under your leadership or under your support, specifically, did you or did you not consult the Chief Justice of the Court of Final Appeal? I answered no. But as I said previously, if the profession has a consensus and if there isn't a large impact to society, if this proposal doesn't have a large impact to society, and given more support, I can discuss this with the Chief Justice. I don't know. CJ might not find this feasible, but if we cannot come up with a consensus, if some stakeholders object, then at this stage I don't think proposing it to the CJ can assist me in any way. Well, I had a very simple question without any assumptions. I just wanted to understand the Law Society. They have a lot of liaison with the Judiciary, the Chief Justice. Well, why don't you seek out the Chief Justice view, Mr. Ma's opinion? Well, just now he clearly answered you. Well, Mr. Hong, in the near future, will you consult Chief Justice Ma? I definitely will. I'll have to ask Mr. Ma one of these days. So when will you consult Chief Justice? I will notify you when I have a firm decision. So when will you have this firm decision? I don't have one now. So, Mr. Hong, when you want to implement the LSE, what is the factual basis or a finding? So the reasoning behind your proposal, would you submit that to the Chief Justice? We would like that, but we aren't privy to that information, so I wonder if the Chief Justice, Court of CFA, will get your proposal. I don't know. I don't have a response. Well, Chairman, Mr. Hong is representing the Law Society, and he's promoting, selling the benefits of the LSE, then why in the presence of our senior officials, the Solicitor General, why don't you have any preparation work? Why don't you make your proposal to the Department of Justice? I'm surprised why Mr. Hong doesn't have a response. Mr. Hong? Well, I definitely will talk to Mr. Chief Justice Ma, but I just don't know when. Well, will you pledge that you will provide the full reasoning for your proposal? I will, but I cannot tell you when. What about your detailed reasoning? Well, whether it's detailed or not, that it's subjective. Well, I think Mr. Hong has answered you already. It's my turn to ask now. I teach at City University, and I also saw the formation of the PCL program in City U in 1991. I also took the PCL program in Hong Kong U. I'm also a member of the Bar Association, so I do wear many hats today.
Now, regarding the report compiled by the Standing Committee, I have been following up on this issue in this panel for 4 or 5 years already. And like Mr. Wong said, apart from the law schools and the 2 legal professional bodies, indeed we need to consider from the perspective of public interest. We need to consider, regarding our legal education training in Hong Kong, how many graduates we have, and I'm happy to see some old faces and some new faces. Mr. Leung, the student representative, mentioned the proportion of LLB and to JD students. Well, because we have more LLB students here, well, I teach in both LLB and JD courses, but not PCLL, so I think I would be more neutral to comment on PCLL courses. Now, I recall back then some of the professors here also took part in the debates. And it was argued that JD and LLB graduates might not necessarily want to become lawyers. So I'd like to seek views from you, since we have many LLB and JD students from various law schools nowadays. Second point about the market, Mr. Chow made the point, and I talked to my colleagues. And after we actively followed up on the issue at panel meetings, indeed we understand that more students have been enrolled in law schools, and over the past 4 or 5 years, I have witnessed cases in which students waited for 8 years before being enrolled on the PCL programs, and finally that student became a lawyer. But we are seeing more and more such cases, including those graduating from law schools elsewhere, those who have obtained a second class upper division. And it seems that the criteria have been slightly relaxed, such that more overseas graduates have been taken on. But I'd like to seek views from deputations here, because Mr. Hong just now raised a point, and I think that this is an issue close to our heart as well. Many students have been waiting for 3 or 4 years. So let's say in future there will be another channel for them. Well, those who have worked in a solicitor's firms for 8 years, for example, who then takes your exam and fails. Will this student be able to wait for another round of PCLL exam again? And what's your take on this? And also your take on the market, whether the market could absorb so many newcomers to the legal profession. We don't have much time. Well, let's see, Mr. Chow, Mr. Hong, and other deputations may comment. Would you like to comment on it? Let me give a start first. The Law Society's stance is that the LSE is not a one-time only exam. We haven't decided on whether anyone can continue to take the exam until he reaches 80. I can really say that this is not a one-off chance. Mr. Chow, the JD of Hong Kong U doesn't take on a lot of students, so I don't wish to comment here, but I agree that not all law graduates need to become lawyers. As for overseas graduates with a second class upper division, we do take a very prudent view, not only just considering the academic qualifications, because from our experience, overall speaking, the person may not reach our standard, although the academic qualification shows a second-class upper division, perhaps because of lack of documentation and also failure in certain areas. Professor?
The student, whether we offer supply or something, yeah.
I'm sorry, is it me?
Professor Hall. Professor Yeah,
Hall
Stephen
or Howell?
Not Howell, yeah.
Thank you.
He hasn't participated. I remember Professor Hall, we had discussion on this before.
Yes, thank you, Madam Chairman. Chinese universities, have been pointed out, take the largest number of JD students of the three law schools. The latest figures that we have indicate that somewhat more than half of our JD students go on to apply for admission into the PCLL program. We take somewhere between 200 and 220 JD students a year. Last year we had fewer than 120 of those students graduating out of the JD program, applying to join the PCLL program with a fairly good success rate, but certainly not anything like 100% success rate getting into the PCLL program. So those figures indicate that there are very substantial numbers of JD students whose sights are not fixed necessarily on entering the legal profession, but who are aiming to use their JD degree to very often, especially in the case of our part-time students, to advance their careers in other fields of endeavour. So I think to suggest that the JD program is in some way crowding out LLB applicants, I think is a misplaced.
Okay. 因為時間亦都夠。
All right, time is up. Let's move on to the second round. 2 minutes for members. Let's start with Mr. Dennis Kwok.
Some basic information about how many places you are proposing to offer through LSE. How many students are you proposing to accept? What are the admission criteria? What would be the numerical impact this would have on the rest of the legal profession? These are basic building blocks. You're talking about a major reform. How can you not have this information with you? Now, Chairman, I have a list of questions which I hope you would pass to the Law Society for written answers after this meeting. But there's been an accusation that the universities have been failing to increase places of PCLL over the years. Now, I just want to know whether that is factually correct. Can I just give, maybe 20 seconds for each law school to answer this question, starting with Mr. Chow, perhaps?
Okay.
Whether you have increased PCLL places in the past years, and what are the, further increase that you can promise now?
Over the past 2 years, because of 2 cohorts of students graduating at the same time, indeed we have increased places. Well, this year, although we do not have the similar situation, we will maintain the same number of places. That means, in essence, there's been an increase.
In Chinese, you?
We took the same approach. We increased, I understand, by 40 in the double cohort and kept those numbers going forward. Right.
Yeah.
So increased by Hong Kong U and City U. Chinese U?
Chinese U has increased its numbers. We started off with 150 when we started our PCLL program. The last time we made a round of offers, we made 170 offers, of which 163 places.
So basically, my understanding is there are about 1,200 applications for PCLL per year, ballpark, and that you're offering over 700
and in addition
PCLL.
To that, Chinese University has placed a proposal before the university authorities to further increase the size of the PCLL program.
Sorry, can you repeat? I didn't missed that.
Sorry, I didn't speak into the microphone.
Yeah.
The law faculty has put a proposal to the university level authorities to further increase the size of the PCLL program.
By how many?
That's a matter that's ultimately for the university to decide, but we are hoping for something in the order of around about, I think, 30 or so further places.
Okay. 跟住落
Next, Mr. Felix Chung. Madam Chair, I don't quite agree with what Mr. Chow Wai-shun said. Well, let's say we have 1,200 PCLL graduates every year. Will the market be able to absorb every one of them? Will they all get contracts? I don't think this should come out from an educator. All graduates should be given an opportunity as long as they equip themselves properly, as long as they join the market, they can just give play to their potential. You can't say because the market is too small, the university should screen out students. That's the wrong concept. We should try our best to groom talents as much as we can. We should not help the market in screening out candidates. You can't say, well, you won't get employed, so why that many places? That's the wrong concept. Under all circumstances, you should give students opportunities so that they equip themselves and fight their own corners in the market. That's what an educator should think. That's just my comment. No question. Next, Dr. Junius Ho, second round. Thank you, Madam Chair. I'd like to follow up on Mr. Chow Wai-shun's point. I think he hasn't finished. Maybe the Law Society, about the Law Society's proposal, the concern is whether there is sufficient market capacity. But I think this is a question to be pondered by the Law Society, not by law schools, not by academics. Very clearly from the Law Society, my understanding is, first of all, there should be a standard, and that's important. And it is not really about opening a floodgate. That's not their policy. That's the first point. Second point, the LSE as a new avenue proposed by the Law Society is another option on top of the 3 law schools and their PCLL courses. I understand under Cap 159, the Legal Practitioners Ordinance, the Law Society is the ultimate gatekeeper. It has the statutory powers to do so. And it's a matter of consensus reached between law schools and professional bodies. Is it the case that graduates coming from all 3 law schools must pass the unifying exam? The answer seems to be yes. So I want to clarify this point. Well, let's say a student performs very well in the PCLL exam, and if the Law Society now requires that the student undertakes another exam, then the Law Society has the absolute right to do so. What's your point of objection? I need to go over to vote. Who would you like to ask, Mr. Chow? Yes, Mr. Chow, you may begin. Thank you for the question. I think the Law Society's proposal is to give another option, is not another hurdle after passing the PCLL exam. That's another path to choose. We need to clarify this. My concern is the prospect of graduates. To say that we are screening them out so that they cannot join the profession, that's not my intention. I was responding to another question just now on trainee solicitor contracts. I'm concerned about their interests or their welfare. Mr. Paul Chair. Well, I need to explain to our guests that because we do not have a quorum because some members need to go over to the other room to vote. And in the interest of time, let me continue. I'm perplexed by Deputy Chair's remarks. I'm an FC member. Well, well, as an FC member, you should be very familiar with what happens to your profession. You should understand their positions, or even defend the positions. So I don't mean to offend you, but I'm really puzzled. I understand the Law Society's views, and just now another member sort of grilled Mr. Stephen Hong whether he discussed with the Chief Justice. When I was sort of surprised because, well, this is not like the appointment of CFA judges that we need LegCo's approval, and yet we should not act as rubber stamps. And I think this is just a well, and I stand to be corrected, Mr. Stephen Hong. Maybe you can tell us whether you need CJ's formal approval for this reform to take place within the legal profession. Second question. In principle, I support this reform, but I think that it's done rather hastily. I want to know the reason why. Mr. Hong. Thank you, Madam Chair. To answer the first question, my understanding is that if we exercise this power, we do not need the Chief Justice's approval.
But as a matter of courtesy, I have to consult CJ Ma, and if he has reservations about my proposal, or if he feels that there's room for improvement, we will listen. And my understanding is I do not need the Chief Justice permission. And the second question, why are we in such a rush? Honestly, I just want to have a date because we need you to understand that the CEE and the LSE are two separate issues, and I would like to see this happen in the near future. We've talked about the common entrance examination for 10 plus years. It hasn't been able to take off. So do we really need a fixed date? I can tell you no. I also understand logistically we might not be able to meet that date. So that's why I said not earlier than a certain date. I would like to see it implemented within a reasonable time. So after my question, I'd like to have everybody summarize or just speak a little bit. First of all, I'd like to understand, Mr. Hong, if you want to implement the test, do you have sufficient resources and staff to see this through? And my next question would be for Mr. Chow or the other law schools, the professors can jump in. Do you feel that the Law Society, by holding this test, might have an impact on your PCLL programs? Are there any concerns? If not, then maybe you won't have such objections. So why do you think there's an impact? And third, I'm not sure if what the other two schools think. We have the deans present, and let's say at City U, the JD programs and LLB programs, when they take the PCLL test, they have their own marking scheme for LLB because the JD is a different program. So I'm not sure if that's done in other schools, but I just hear that's how it's done from my colleagues. And the third question, perhaps you'd like to also respond, and Mr. Edward Chan would also like to jump in. The government can also speak if they wish, and let's say Let's have Mr. Edward Chan go first. Well, first of all, the bottleneck. That is a policy issue. So, where does the bottleneck occur? Should it be at the academic or at the vocational stage, at the PCLL, or do we have to wait for all the students to have finished their basic education and before they take up the training contract or pupillage? Where do we set the bottleneck, or should it be determined by the market? Because that's a policy issue, and everybody has a different perspective. But barristers also have a concern. In our expert report, it's said that the data they collected, people who pass the PCL and receive a training contract, it's some 80-90% for solicitors, and that's quite ideal. But you have to bear in mind that even if you increase the quota for PCLL, if you increase 20-30%, I don't think there will be any change in the ratios. So it doesn't mean that you can get a pupillage. So if we have too many channels for the solicitor program, then the people who don't want to become barristers, they end up joining the barrister, and that is not good for society. I also want to respond to the view that we there's a call for change. The three law schools have different enrollment programs. The curriculum not the same, and the examination is not the same. And now if you create an LSE, you create a fourth examination, and they say they want it to be at the same level of the PCL. We don't know which program would be, which program they're referencing. So Mr. Hong's proposal, the biggest difficulty we feel is that the Law Society hasn't provided further news. The Law Society in the past, when they did the consultation report, nobody was aware of it. And up till now, with the Law Society, we don't know what they have in mind. So we feel, given these conditions and you want our support, we find that very difficult.
To add that, okay, Professor Howell, please.
Yeah, thank you. It's been an interesting discussion, and of course...
Speak to the microphone. Yeah.
Can you hear me?
Yes.
Thank you, Madam Chairman. It's been an interesting discussion, and of course the number of PCL places and the ratio between those places in the job market are not really questions for the university as such. But I think my concern is to have, in a pool of 1,200 students, two competing courses aiming at the same students. There must be a rationale why you would choose one course than the other. And simply because you can't get onto one course doesn't seem to be a good reason to create another course. Because if that's the only reason for it, those people are going to be seen as the ones who didn't make it into the top flight, and that wouldn't be giving those people the best start going forward. What I think would be interesting would be to be more radical and perhaps build on the discussion about legal executive training and think of a model where people who've been in the profession as legal executives or have done a law degree and then gone into the profession as paralegals or legal executives can have a vibrant alternative route into the profession which is distinct and different from the PCL and meets the needs of a different group of students. But to have the same course aimed at the same cohort of students doesn't seem to me to be the best use of our limited resources.
好，對唔住，因為咧我哋時間真係有限，下一輪嘅
We do have time concerns, and our next round of guests have arrived. So, because of time constraints, I have nothing to add. Okay, the Deputy Chairman also has some written questions, and I've promised to submit these to you.
Please submit to our panel in writing. We will certainly consider all your views, okay? Thank you all for your coming, because it's a very, very valuable time for us to understand the new proposal and all the views of different universities. Thank you very much. Thank you.
So we have to invite the next batch of officials. I'm not a member of this panel, but I want to speak on item 5. I would like to speak on the miscellaneous sex offenses. Will you postpone it to the next meeting? Because you don't have time. You have to finish at 7. Could you move it to the next meeting? Okay. We have to thank the Secretary of Justice. We now move on to agenda number 5, the Law Reform Commission of Hong Kong's consultation paper on miscellaneous, or rather item 4, implementation of the recommendations made by Law Reform Commission of Hong Kong. And our previous item, we overran. We also had to vote, and we had to postpone. So in light of Ms. Elizabeth Kwok's opinion, and if the government agrees, we would like to take the last item, item 5. We might need to postpone it to the next meeting. So the next item, we have a deadline for the consultation. It will end in August. Well, I have discretion. I can add 15 minutes, and if our panel agrees, we can extend the 15 minutes, and we can try our best to deal with the agenda item. Let's start. So first of all, we'll invite Ms. Teresa Zheng to take us through the paper. Well, Chairman, this is the first time as Chairman of the Law Reform Commission that I report to the AJLS panel. Now, as Secretary of Justice and also Chairman of the Law Reform Commission, I have a responsibility to, in line with the other relevant bureaus and departments, to report on the implementation of the recommendations made by the Law Reform Commission to this panel. So, the CFA, CJ, LRC members and myself, we choose appropriate subjects for the LRC to consider, and we also have to take on board the views of the relevant bureau and departments. So, members and chairman, in light of the information paper, we have the first report from 1982, and we have a progress report on the LRC. The LRC has issued 65 reports regarding civil and criminal law, and they had put forward the different recommendations. So in the 65 reports, one report recommends that there should be no changes, and in the other 64 reports, we have a progress report, and we can divide it into 5 areas. The first area, we have 35 reports, recommendations where they have all been implemented, and that makes 54.5%, 54.7%. And the second category, we have 8 reports, and there are partial implementation, and that is 12.5%. The third category, we have where there are 15 reports, recommendations that are under consideration or in the process of being implemented, and that is 23.4% of the 64 reports. And the fourth category are 3 reports where the proposals were rejected by the government, and that is 4.7% out of the 64 reports. And the fifth category, where the government has no plan to implement the proposals at this juncture, and that is 4.7% of the 64 reports. So overall, in the last year, there has been positive progress in the implementation. For example, we had legislative implementation. For example, the Legislative Council in 14th of June 2017, there was arbitration and mediation, third-party subsidy amendment, and that we also issued a report, and the relevant that enhanced Hong Kong's status as an arbitration center and a financial dispute resolution center. And there were also hearsay in criminal proceedings, a report issued in November 2009. The DOJ briefed the panel on 27th of March 2017, and we had consulted the AJLS panel and other stakeholders.
The consultation period ended on the 31st of July 2017. The Department of Justice have considered the consultation outcome and is in the process of finalizing the proposal. In early July, the draft bill being refined is expected to be introduced into LegCo. As for enduring powers of attorney, personal care, published in July 2011, at the Interdepartmental Working Group, the DOJ examined the recommendations in the report and launched a public consultation on a draft bill on the 28th of December 2017 and briefed the panel on the consultation on the 22nd of January 2018. The consultation period ended on the 28th of April 2018. The administration is looking at the results of the consultation and is planning to introduce the bill into LegCo in the 2018-19 legislative session. As for Insolvency Part 2, Corporate Rescue and Insolvent Trading, report published in October 1996, the Financial Services and Treasury Bureau announced a package of legislative proposals and has issued the drafting instructions. The target is to introduce the bill into LegCo within the 2018-19 legislative session. In relation to double jeopardy, report published in February 2012, the DOJ is prepared to consult the stakeholders and work out details of the legislative amendments. Both the LRC and myself attach great importance to whether the LRC recommendations can be effectively implemented. And at each LRC meeting, we would discuss the progress of implementation. And the DOJ also works with the relevant policy bureaus on a regular basis, requesting them to report on the implementation progress, and such reports are also uploaded onto the LRC's website for public access. We'll continue to work with the Law Reform Commission, this panel and other panels of the Legislative Council to monitor the implementation status. Finally, I'd like to thank this panel and all members of the Legislative Council for their concern and their support over the work of the LRC. Thank you. SJ, anything to add from Mr. Wong, the Secretary? No. All right, I'll open the floor. We have 3 members. Each will be given 4 minutes, starting with Mr. Charles Mok. Thank you. In fact, I'm not a member, but I thank Madam Chair for allowing me to ask a question. I'm concerned about the archive law and access to information. I'd like to know about the work of the LRC because I remember last year it was said that in the beginning of this year there will be a report, and then in the beginning of this year it was said that later this year. So far I haven't seen this report. Can you tell us the progress? Because I heard previously that you are reaching the final stage, and Secretary, could you please tell us the progress? Regarding the two reports, the relevant draft in both languages are nearing its completion. I cannot tell you any specific timetable, I'm afraid. Mr. Wong? The relevant consultation paper should be ready soon because we are reaching the final stage, as pointed out by the Secretary. In terms of the drafting work, we are reaching the final stage. Sorry, I haven't heard you clearly. Within when? Within this year. All right, within this year. So please speed it up because we have been waiting for a long time. What follows will be consultation. And if we need to enact legislation, if that's the recommendation, I hope that it can be done as soon as possible because we still need to go through consultation. Deputy Chair, Mr. Dennis Kwok. I share Mr. Charles Mock's view. I'm also concerned about the archives law and access to information, and we in fact have a private bill on this matter. If the government is willing to take this up, I hope this can be done as soon as possible. This is also the CE's promise. And Secretary, you should understand I'm concerned about class action. We have had over 20 meetings. So objectively speaking, can you tell us when there will be some results so that we can follow up on them? Secretary. Now on class actions, the working group and the subcommittee held 22 and 28 meetings respectively. We are awaiting a report from the working group. Following that, we'll actively study this issue. And there are technical issues that require some time to be carefully examined. I am afraid I cannot tell you a concrete timetable when exactly the report will be ready for follow-up. All right, I do hope that this will be done as soon as possible, because this is a concern of the legal sector as well as the public. In terms of arbitration, well, Secretary, I know this issue is also close to your heart. Do you think that the Law Reform Commission should look into, say, conditional fees and other matters, specifically on arbitration, not other areas of litigation? Do you think it's necessary to look into the issues again and perhaps have consultation? Secretary, we have an advisory committee on arbitration, and this comment is equally raised there. We are going to discuss this issue at the advisory committee before we chart our way forward. Your predecessor, Mr. YEUNG, mentioned that he would like to make the secretariat and staff of the LRC more professional. That is, whether we can have full-time legal researchers there instead of relying on, scholars, solicitors, barristers from the legal profession who, of course, have contributed their valuable time to the work. But the point is whether there are resources to turn LRC into a more professional body. Well, under the existing resource constraints, we do understand the LRC has a heavy workload. Apart from compiling reports, the LRC is also tasked to liaise, the Secretariat is also tasked to liaise with policy bureaus. We try our best to cope, but it takes time for us to thoroughly study the issue. Next, Dr. Junius Ho. Thank you, Madam Chair. Secretary. Well, the LRC doesn't seem to be really busy. 65 reports have been compiled through some 30 years. Some 35 reports have been implemented in full. Some are old issues. For third-party funding for arbitration, in light of the development in Hong Kong, the issue became quite urgent. But I'm not quite sure about the pace of the LRC's work. Debt collection, for example, a report was compiled in 2002, and that it was put on the back burners. No progress heard. And there are also other, from 2002 to 2016 or 2018, that's been 16 years. If a report has been compiled, I want to know whether there is a benchmark of your performance or performance pledge. After the LRC's published a report on the part of the administration, you should decide whether to go ahead with the proposal in, say, 5 years. We should have an indicator, because at the moment it's a bit hazy. And for more urgent issues, you need to work more expeditiously. I think we'll work with you. There are other issues that are important, class actions, for example, as pointed out by Mr. Dennis Kwok. We should go ahead and it should be done more expeditiously. Adverse possession, that's item number 58. Another example. It's being studied at the moment. Land is very important in Hong Kong. Adverse possession, however, really stirs up a lot of conflicts in the community. A trespasser or an occupier can become a landlord through this mechanism. Well, as the landlord, I sometimes, may have neglected that, and after some years, the occupier, without paying rent, could become the landlord, and it's really contrary to our principles. So we should have an indicator how long it takes for the government to consider the LRC's recommendations, whether to take it forward or not. And for some urgent issues, adverse possession, whether you would speed up your work, Secretary. First, on whether we could have an indicator. In October 2011, we set up a mechanism, hoping that 12 months after the report has been published, the Policy Bureau could give a concrete answer whether to accept the recommendations in the report. Or at least an interim report should be submitted in 6 months' time so that we understand the progress. And we're following up on the matter in 2012. Another mechanism was put in place, as I do now, to report to the panel so as to report specifically on the implementation of recommendations. I think that an indicator would be difficult because for policy bureaus, they may have their own priorities and considerations because of resource implications in implementing LRC's recommendations. It is therefore difficult to come up with a blanket indicator for all the recommendations. Please continue, Secretary. Third point, about whether an LRC report should be implemented sooner or later. As I said in my reply, that depends on the policy bureaus concerned. And finally, in fact, in the annex, members would see when the report was published and the follow-up made. They're all set out in the annex. All right, my turn. I'd like to put on record, because I'd like to follow up on paragraph 20 about stalking. Follow-up action on legislating on stalking, because I recall some journalists or some celebrities may be involved. I hope that you will not put that on the back burners, and it is said here that something would be done to follow up on anti-stalking legislation. I do hope so. Just now, Dr. Junius Ho made another point on adverse possession, and at this panel we had quite a few detailed discussions. Well, some some landlords might be quite forgetful, and in the community, sometimes an elderly owner might authorize a relative to collect rent, and as time goes by, there may be cases of adverse possession because of neglect on the part of the relative. On the other hand, some occupiers might have been using the place for a long time, and there is a need to strike a balance. We need to hear the justifications from both sides, so I do hope that this matter will follow up on. And the third point, since the Secretary is here, I have another point to make. I thank the former Secretary, Mr. Rimsky-Yuen, for his work, and I'd like to now ask about the resources for the Secretariat of the LRC. Mr. Wong, there are so many issues in the community that requires examination by the LRC. Do we need more resources? Do you think that we should follow up on this issue? We'll be happy to do so. Well, about enhancing resources for the LRC, there is a need. We understand in December last year, the members indicated their support for enhancing the resources for the Secretariat of the LRC so that we can speed up our work.
So the DOJ will make arrangements. We'll see how we can add human resources. In the previous discussion, we explored the option of subcontracting the research to experts, and that is also under consideration. CJ, anything to add? Well, if Secretary of Justice, nothing to add, and if legislators have asked no more questions, we'll conclude this item, and we will move on to the last agenda item, and that is the Law Reform Commission of Hong Kong's consultation paper on miscellaneous sexual offenses and consultation paper on periodical payment for future pecuniary loss in personal injury cases. There is a deadline for the government consultation, so we invite your views. The paper is CB 41109/1718 bracket 0102 and bracket 07. That is the consultation document on the periodical payment for future pecuniary loss. So members who are interested, you can press the button and we will have representative from Law Reform Commission to speak first. Well, we haven't started the clock yet, so could you switch off the clock first?
It would be Mr. Peter Duncan, SC. Thank you very much. May you start to present your ideas.
Thank you very much, Madam Chairman, and good evening to you and to members of your panel.
Yeah.
I'm pleased to be able to present to you our consultation paper on the matter of miscellaneous sexual offences. This paper was published in May, and it is the third and the final part of our overall review of substantive sexual offences. It covers a number of miscellaneous sexual offences such as incest, exposure, voyeurism, bestiality, necrophilia, acts done with intention to commit a sexual offence, and a review of some homosexual offences which still lie within our legislation. Apart from making some recommendations to reform some of the current existing sexual offences, the subcommittee is also recommending introducing a number of new specific sexual offences. These reflect our general approach of four principles: the protective principles, gender neutrality, respect for one's sexual autonomy, and the avoidance of any distinctions based on sexual orientation. I'll go quickly through the main particular offences that we have recommended. The first is the offence of incest. We have recommended that be retained, but that elements of that offence should be reformed. There are some issues which arise from our consideration of that offence. For example, whether it should be confined to sexual intercourse or whether it should be extended beyond that to other forms of sexual activity between close relatives. Secondly, an issue arises as to whether it should extend beyond natural parents to, say, adoptive parents. Thirdly, it should be, in our view, be extended to blood relatives such as blood uncles and aunts not covered by the current legislation. Moving from incest, we've proposed the creation of a new offence of sexual exposure. This is to cover that sort of activity where the object is to target a specific person or to threaten that person or to alarm that person, or to obtain sexual gratification for that sort of activity. This is to be distinguished from the existing offence of indecent exposure, which is known as a public order offence. Turning to the proposed creation of the new offence of voyeurism, we consider that there should be legislation to cover acts of non-consensual observation or visual recording of another person, again for a sexual purpose, whether that other person is entitled to believe that he or she should be entitled to privacy in those circumstances. Bestiality, I think the proposals for that are self-explanatory. Necrophilia, surprising to many, is not currently an offence in Hong Kong, and we believe the time has come for that to be legislated. There are a number of offences with regard to the acts done with intention to commit a sexual offence would perhaps not be caught by the common law concept of an attempt, and we've recommended changes in the law to cover that. And then finally, as I mentioned, there are a number of existing homosexual sexual offences still on our statute books, and we believe that they should be removed. So, Madam Chairman and members of the panel, that's a very brief but hopefully helpful introduction to the matters that we've covered in our consultation paper. And my colleagues, myself, would be very happy to answer any questions that you may have.
Okay. So now I would like to, any further presentations? No, not yet. Yeah. So I would like to introduce Mr. Nicholas Piri from the Bar Association. May you take up the speech now?
Well, I have nothing to add about the sexual offences. Okay. I'm concerned about payment today.
Okay. So how about the others?
Nothing
not yet. Okay. So maybe now, yeah. Hi.
嗰個 payment 嗰度啊，即係因為我哋一問咧，我哋即刻問埋兩個問題啊嘛。
Could we also hear the officials' presentation on the periodical payments? We can ask questions in one go.
The panel, thank you for the opportunity for me to come to discuss with you the topic of periodical payment for future pecuniary loss in personal injury cases. The consultation paper was published on the 25th of April 2018. And the impetus for the study on the topic was because in 2015, after a decision in the High Court, the Secretary for Justice and the Chief Justice tasked the Law Reform Commission to look into this topic of payment of future pecuniary loss in personal injury cases to see if any reform is needed so as to allow the introduction of periodical payment for payment of future pecuniary losses in PI cases, and to make appropriate recommendation if necessary, including the viability and desirability of having a mechanism to decide the presumed rate of return of investment, which is an element in the assessment of future loss in PI cases. And traditionally, as a matter of law, both special damages, that means damages incurred before judgment or settlement, and also future losses and expenses, that means post-judgment expenses as projected by the judge in a trial or by those advising the parties in a settlement, has to be arrived at following the principle of restitutio in integrum, meaning that as far as money can buy, the injured person will be put or restored in the circumstances where he had not suffered the injury. Practically, that would mean that the award of damages will be crystallized once and for all at the time of the trial or at the time of settlement. And history and experience will tell us that such an approach, which is basically by applying a multiplier to a multiplicand in arriving at a lump sum, would invariably be inaccurate in the sense that it can only be either too high or too low. And therefore, the conventional approach to quantify future losses by using the multiplicand and multiplier model established by case law has been generally criticized as being imprecise and unscientific. In the recent case of Chen Pak-ting, decided by Mr. Justice Bawani, he drew attention to the experience in United Kingdom by reference to Section 2 of the Damages Act 1996, which, following several successive reform, has come to the stage since 2005 that the court, despite the views of the parties, would, in the circumstances which is deemed to be in the best interest of the parties and for the proper administration of justice, to introduce and to order payment of damages for future loss by way of a periodical payment order. One particular matter that is closely related to periodical payment is the fixing of the discount rate. If the amount of damages that is to be incurred in the future to cover losses or future or expenses to be incurred in the future, if the sum is not discounted, the injured party will be overcompensated. And therefore, there has to be a discount rate to be applied. That is a perennial problem, and as pointed out by Mr. Justice Bawani in the case of Chen Pak-ting, the individual litigants would not have the resources, and in fact it is not conducive to proper administration of justice to have individual parties to mobilize resources to argue the appropriate rate of discount on the amount of damages to be received in PI cases. And therefore, the subcommittee also look into the viability and desirability of introducing a mechanism for fixing the discount rate. There are a number of questions identified in the consultation paper in respect of which we solicit the opinion of the public. It is noteworthy that in this particular consultation paper, the questions identified are framed in an open manner so as to engender comprehensive discussion on the topic. Question one basically is...
Sorry, Mr. Leung, I need to inform the panel I have to exercise my discretion to extend 15 minutes. And if necessary, we may extend more with the consent of the members present. It depends on how many questions and how many members would follow the issue. Okay? Mr. Leung, please continue.
Yes. In the interest of saving time, I would be very brief on the question because it's very well and detailedly set out in the consultation paper. The first question is whether or not, as a matter of principle, the court should be invested with the power to order periodical payment for future pecuniary loss in the personal injury cases. The second question is whether or not a mechanism should be introduced for the fixing and reviewing of discount rate, and if so, who would be the authority to fix the discount rate, and what are the interest party or stakeholders who should be consulted during this periodical review. The third question for public consultation is the aspect of whether periodical payments should be introduced in the situation where the consent of the party is not forthcoming, and also whether there should be any limit to the type of case or specific criteria for deciding the situation where a court can impose a periodical payment order. Question 4 concerns the circumstances under which the court may review periodical payment order in related contingencies, and whether the current regime of awarding provisional damages should coexist with the periodical payment order regime. The last question concerns the issue of security of payment under periodical payment order, and the stakeholder, in particular the insurance industry, are welcome to explore the various modes of securing the payment so as to ensure that the receiving party, the injured person, would have the stream of payment secured and would not be exposed to further uncertainties. The consultation period will last until the 24th of August, and we look forward to receiving the submissions from all stakeholders and interested parties.
Okay, thank you, Mr. Leung. Any additional comments from the bar? No. 我諗而家呢就係我哋委員嘅時間。Yeah.
Well, the floor.
In the bar's response, we have dealt with funding options, and I think this is a major problem which has not been considered, which will be considered by the insurers. First of all, the security issue is a big problem because in UK, most of the accidents that involve PPOs are motor insurance cases, and they're not long-term insurance. They don't have long-term insurance registration. And secondly, in Hong Kong, probably most of our cases will be construction site cases or damaged babies with cerebral palsy. Those insurers are not long-term insurers registered under our insurance company's ordinance. So they will seek in any event probably to capitalise their payment with a third party, and that is why we've suggested a third fund for someone like the MIB to administer. Then you don't need to deal with the security of payment issue. So far as the medical insurers are concerned, they're not onshore in Hong Kong either, so that is an issue which would have to be covered. The other thing I think is a practical one. Most plaintiffs in Hong Kong want their damages in their hands, usually to buy a flat, because they need somewhere to live. And under the existing law, the cases Roberts and Johnson, they only get a capital allowance of 2% of the capital value of the flat. So there will be very few applications from plaintiffs, I suspect. So we have an unknown number of people possibly wanting PPOs, and is it worth it setting up a court of protection, something like that, or another institution to pay for these things when there is an unknown number, and it would seem much better if the government would consider funding, say, a third fund for MIB or someone else to administer. That would solve a number of those problems. Thank you.
Okay, thank you, Mr. Perry. 跟住係我哋為
Thank you. Questions from members now. We have 3 members. Each will be given 4 minutes. Questions and answers included. Let's start with Dr. Helena Wong. Thank you, Madam Chair. First of all, I thank the Law Reform Commission for preparing the paper for us. The Democratic Party has carefully looked into the consultation paper. Basically, we support your recommendations, in particular about gender-neutral sexual offences. We agree with the amendment. But I have reservation about one point: incest. About recommendation 1, you propose or you ask whether the new offence should cover adoptive parents. And from your paper, I have the feeling that adoptive parents should be covered, and we agree with it as well. However, about adoptive parents, step-parents, and foster parents, I see differential treatment. Your view is that adoptive parents should be covered by the new offence of incest, whereas for step-parents and foster parents, because they have no blood relation with the child and that there are other relevant offences to protect the child, your argument is that step-parents and foster parents should not be covered. But when it comes to blood relation, adoptive parents do not have blood relation to the child either. So I want to know the rationale behind differentiating adoptive parents and step-parents and foster parents. And 1.18 and 1.101 of the consultation paper, you have quoted from the review committee of the UK, and then it is said that the new offences scope should cover parents that have lifelong trust and responsibility of the children. So be it the UK Review Committee's recommendation or otherwise, since children also live in the same unit as their foster parents and step-parents, I want to know the rationale of the differential treatment in your recommendation, whether this will create a loophole or that there will be a public perception created that it is not incest if it is done between a child and a step-parent or foster parent. The Democratic Party is very concerned about it. I want to know the administration's understanding. Mr. Eric Cheung. Of course, the consultation period is still ongoing, and we're happy to seek views. We're here to explain the different ideas. It's not a finalized view. Now, regarding adoptive parent, the major difference, legally speaking, from a step-parent or a foster parent is that as far as the adoptive parent is concerned, the position of the law is that the adoptive parent goes through a formal legal procedure to adopt the child, and it takes up all the legal responsibilities of the child. And in some cases, the child may not even know that he or she is adopted. So the situation is different from a step-parent or foster parent. In the case of a step relation, the child's parent may be married to another spouse, and the child will be in a position of knowing that it is a child, it is a step parent. For foster parent, well, the definition is vague. It may be the child sojourning in the foster parent's place for some time, and the idea is different from the UK law. In the UK law, the concept is not about incest, but about possible abuse under the same roof. The basis of incest is even if the child is of age, as long as it's captured by the offense of incest, the person will still be committing the offense. And we need to consider not to overextend the scope of the offense. Well, I see members are interested in this discussion as well, and I'd like to seek members' consent to further extend this meeting to 7:30 so that we can allow all members to ask questions. Mr. Ray Chan. Second, well, thank you, Madam Chair. I have one comment and question, another question as well. And Madam Chair, this is a comment for you. I hope to call for a public hearing regarding miscellaneous sexual offences. I understand it's difficult because the consultation paper was published in May, and we're here in June, and we only have this opportunity to discuss now, and our panel will be in recess in July. I wonder if we can have a public hearing on this. Sometimes the administration may extend the consultation period. I wonder if the administration would consider extending the consultation period for this paper. And if it is still not possible, I wonder if, let's say, if we have a public hearing in September, whether the views would be will be included in this consultation exercise as well. And I have a question on Chapter 7, homosexual or homosexual-related offences, homosexual-related buggery or gross indecency offences. I'd like to first of all point out the confusing situation regarding the use of Chinese and Chinese and English language. Say the title of Chapter 7, Review of some existing homosexual-related buggery, so on and so forth. So, if we want to express homosexuality in Chinese, the word should be homosexual, not same-sex. Well, because in the Chinese version, the wording is not consistent. Sometimes you use the word meaning homosexuality in English. Sometimes you use the Chinese word meaning same-sex. So I think there should be consistency. It is proposed that 118 B, G, J, and K. You're proposing to repeal or abolish the offences relating to buggery between two men, so that you achieve gender neutrality. However, regarding other offences, 114 and certain sections 114, well, it's not gender neutral. For example, for buggery relating to a girl, the age is still under 21. So it is, well, it seems to be inconsistent. Now, for other offenses that have a gender element, I want to know whether the LRC will deal with it in one go, or there will be another exercise. Another point is on sentencing. Well, the sentencing will only be explored in the fourth paper. However, the LRC is going to publish a consolidated report after the third report has been published. Some organizations are concerned whether the sentencing part will be neglected. And there is a concern on the lack of consistency regarding sentencing of offences of sexual offences between men to men and women, and whether there will be any inconsistency. LRC, Mr. Eric Chung.
Okay. Given the Chinese language implications.
Yeah.
Thank you.
Okay.
Very briefly, let me respond to that. I may not be able to respond to every point. For the Chinese translation, for example, frankly, we drafted it in English and then we passed on the report to the translation officer. I think Mr. Ray Chan's comment will be looked at by them. The other point is on sexual offences. Right, gender-related offences. Well, I seek enlightenment from the Secretariat, but my impression is this. Initially, in our consultation paper, we set down a very clear principle that there should not be any gender implications or discrimination against somebody's gender. Regarding the offences set out, which we propose to be abolished, the origin is that is this. Now, regarding gender neutrality or avoidance of distinctions based on sexual orientation, in previous consultation papers, we touched on the subject. And in general, there should not be any distinction. But I cannot specifically tell you a certain provision. I need to refer to the previous reports. Then can you give a promise? Say, previously you may have dealt with the age threshold difference between genders and the sentencing tariff. Well, I cannot really give you any undertaking because we're limited by the terms of reference, but the direction is clear. From the several previous consultation papers, we have set out our directions, our principles, but ultimately the recommendations are not really implemented by the Commission. Anything to supplement? Mr. Eric Cheung also mentioned just now that we follow certain principles in putting forward recommendations. For example, there should not be distinction or discrimination based on sexual orientation. As for individual offences, as pointed out by the subcommittee in the beginning, for the first 3 parts of the consultation, there would be consolidation. For example, offences related to children. After views have been collected, they will be dealt with in one go.
陳健波議員。
多謝主席。嗱，我會就改革按期支付未來金額損失個賠款嘅發言嘅。我首先多謝阿貝禮大律師咧，係就講得出我哋保險界嗰個關注。咁我好認同佢講嗰啲嘅，特別係有啲所謂一般保險嘅係咪應該承擔一啲長期保險嗰種責任咧？將來點做咧？咁樣嚇。咁但係我首先講咧，就保險界咧將會係好詳盡咁回應個諮詢文件。但係喺呢個階段咧，我想指出2點啊。第一咧就係話呢個改革咧係會影響個法定強制性保險嘅險種嘅，例如係僱員保險啦、汽車保險啦、船舶保險啦，同埋呢個法律責任嘅保險嘅。咁涉及咧幾十萬嘅投保人，當中有僱主啦、車主啦、駕駛人啦、船主同埋營。
It will affect operators, incorporated owners of buildings. So this amounts to more than 10 billion per year. So any change will lead to an increase in premium, and Hong Kong premiums will go up by 500 million. So for the insurance holders, this is something that all insurance subscribers will have to consider. So before we implement this, we feel that there should be independent, in-depth review to investigate the cost-benefit analysis, whether it's in proportion, and we should also meet with the automobile owners and other stakeholders. We also suggest that the government should consider how to calculate the discount rate, because if this future discount rate, if it cannot move in line with the economic data, then the applicant's compensation will be out of touch with reality. So on the issue of discount rate, this goes beyond the PPO issue. So the LRC should conduct an independent study. We should study the discount rate first and to see whether we need to authorize certain institutes or bodies to determine the discount rate. Now, I know that you will be meeting with the insurance industry because they are an important stakeholder, so I hope that you can hear their views. That's an opinion. Would you also need a response? Anybody would like to respond? Well, the 2 points Mr. Chan Ginbo mentioned, we have heard of them, so Mr. Chan can look at paragraph 6.70, we have responded to that. Now, when we drafted the consultation paper, we were aware that the insurance industry would have some concerns, and during the consultation, the insurance industry will have sufficient time and resources to respond to these. And of course, there's a meeting on the 3rd of July, so I hope there can be more communication. Yes, we want to assure that the plaintiff can receive an appropriate amount of compensation, but we also have to bear in mind the impact on society. Next, we have Mr. Dennis Kwok.
I have a question regarding the periodical payments consultation, especially in relation to question 3, subsection 2, where you talk about the circumstances where it would be just and fair for the court to order periodical payment. But I'm interested in knowing what sort of factors would the court normally take into account to decide this question, and how you can help people to understand the consultation, especially this question, a little bit better.
In fact, if one follows the model of other overseas jurisdictions, the circumstances under which the court will review the terms of a periodical payment order is, in fact, very limited. It has to be the circumstances which is anticipated upon expert advice at the time the order is made. In the event that there is anticipated major deterioration on the condition of the recipient of periodical payment, or in the event of substantial improvement of the condition of the recipient, then there will be very detailed criteria set out at the time the order is made for either party to come back to court to seek a variation of the order. And there will also be a limitation on the number of applications that can be made. And therefore, it is not an open-ended commitment. And that is basically a question that is geared towards this type of situation, so as to do justice to both parties. And in fact, the adjustment on the basis of substantial improvement of the recipient is something that is new. That will not be the same as the current regime of provisional damages as allowed by the rules of High Court as it now stands.
Yes, thank you for that clarification. I think this is set out also in the body of the consultation paper.
Indeed.
Yeah. And also, in terms of timetable, what are you looking at? I mean, this consultation will go on, and when do you expect to produce a report so that we could help you push the government to, you know, adopt your recommendations and take this forward?
Well, I don't think I can say anything to bind my colleagues and also those assisting us. Of course, to a large extent, it depends on the number and volume of the submission that we received upon expiry of the consultation period on the 24th of August. But in a rough and ready approach, I personally would be aiming at producing a final report within about a year. And it is contemplated that if the result of the consultation is such that we feel that we are in a position to make more definitive recommendation, we will perhaps attempt a draft of the legislation that is needed to bring about the reform so as to expedite matters.
好，首先呢就多謝大家先，有冇任何
Thank you. If we don't have further elaboration, just now Mr. Chen Jichun hoped that we could have a deputation hearing, so I will ask other legislators and I have an open attitude, but we do have a very tight schedule, and if we don't have the time, I would like LRC to hear our views. So if we have some late submissions, I would like you to still hear them. Now, I feel that our colleagues' questions need to be responded to. We might need a little extra time. So we will notify you whether we can hold a deputation hearing. So I hope you can accommodate our schedule. If we still have legislators with views, I hope you can take those views on board.
The public hearing on the matter, and I think the matter is very worthwhile for discussion, further discussion. And thank you all for coming today for such a long meeting, for all these issues that has drawn a lot of concern from our panel. But your opinions have been very, very valuable for us. Thank you very much. Thank you.